Hearing in the appeals of Grandview Private Trust Company and another against Wong and others.
Yes.
May it please your Lordship and your Ladyship, I'm here with Mr Hagan, Queen's Counsel, Mr Atride Sterling, Ms Hargreaves and Ms Thompson for the appellants in appeal number 64. Those appellants are Dr Wong, Dr Winston Wong, his grandson Riley Wong. Mr Wilson, Queen's Counsel, with Mr Wheel, Ms Rana Fay and Ms Benson appear for the appellants in appeal number 65. That appellant is Tony Wang. And Mr Howard, Queen's Counsel, Mr Adkin, Queen's Counsel, Ms Nairn, Queen's Counsel, Mr Smith, Mr Mohammed Bai and Mr Venkantasan appear for the respondents to both appeals. That is Grandview Private Trust Company as trustee of the inaptly named Wang Family Trust. Inaptly named because it is a purpose trust from which none of the family members can ever benefit. The other party to both appeals, Jennifer Wang, does not appear. Your Lordships and your Ladyship will have seen that there are two main points on Dr Wong and Riley Wong's appeal. The first is whether the entirety of the transfer of the entirety of the Global Resources Trust assets to the Wang Family Trust was outside the proper purpose of the powers that trustee was given and was therefore void. And the second is whether the prohibition in Clause 9 of the GRT trust deed against transfers to other settlements which might infringe any applicable rule governing remoteness of vesting was applicable and was breached to that applicable to that transfer and was breached by it. With your Lordships and your Ladyship leave, I will address the first of those 2 points, and Mr Hagan, Queen's Counsel, will address the second. On timetabling, I hope your Lordships and your Ladyship saw that the appellants would like to bring over half an hour to their main submissions, and so the timetable is rejigged with the appellants in total.
We have the proposed timetable and we're content with that. Thank you.
I'm very grateful. Lords, M'Lady, this appeal, we say, brings into sharp focus the question of whether, when a settlor gives his assets away to trustees to hold on trust for identified beneficiaries, in this case it was the economic settlor's issue, with discretionary powers of appointment, advancement and resettlement in favour of his issue, with power to add to and exclude from the objects of those dispositive powers, whether that trustee is entitled to exercise those powers in a manner which ensures that those beneficiaries and those original objects of the discretionary dispositive powers cannot ever benefit from any of the trust assets, for that is what happened in this case when the trustee of the Global Resources Trust, which I'll refer to as the GRT, added and transferred to the entire trust fund to Grandview. Put another way, the question is whether powers of addition and exclusion of objects of discretionary dispositive powers and the exercise of those dispositive powers gives the trustees maximum flexibility, as the Court of Appeal referred to it and as my learned friends put it, which permits them, the trustees, to change the entire nature, character or substratum of the original trust, or whether those powers are limited by reference to the purpose of the original gift into the trust. We say that's the substratum of the trust, so as to prevent those powers from being used to destroy the trust's original character or substratum. Our submissions rest essentially on the following propositions. First, a fiduciary power can only be used for the purpose for which it was conferred. Secondly, where fiduciary powers are conferred in a trust, identifying the purpose for which the fiduciary power has been conferred involves identifying the purpose of the trust. Where the trust is created for the benefit of the settlor's family members, benefiting the settlor's family members is, we say, the purpose of the trust. That is the trust's substratum. And the purpose of the fiduciary powers in such a trust are there to assist the trustee in fulfilling, not destroying, that purpose. Objectively, and given the nature of the trust they have created, that is what the settlors of the trust can reasonably be considered to have contemplated the powers they bestowed on the trustee being used for. One just puts that into the negative, and it gives rise to what we say is the substratum rule. Because putting it in the negative, the rule is, we say, that a trustee is prohibited from using its fiduciary powers to destroy the substratum of the trust it has been entrusted to fulfill. So applying those propositions to this case, we say the purpose of the original gift to the GRT was to benefit YC and YT Wang's family members. Their issue were both the beneficiaries of the trust and the objects of the discretionary powers of disposition. The fact that they were identified both as beneficiaries and objects of those dispositive powers stamped the trust, we say, with the character of a trust for the benefit of the settlor, the economic settlor's families. The GRT was therefore a trust for the benefit of the family. That, we say, was its substratum. The powers given to the GRT trustee were given to fulfill, not to destroy, that purpose or substratum. Put another way, it is not reasonable to suppose that when they settled the GRT for the benefit of their issue, YC and YT Wang contemplated the trustee using the powers that it was given to ensure that none of their family members ever benefited from its funds. It's not reasonable to suppose that YC and YT Wang contemplated the trustee destroying rather than fulfilling the original purpose of their gift to the GRT. Now, walking through those propositions requires an analysis of the purpose of the original gift, particularly because the Court of Appeal said, and my learned friends say, that the GRT essentially had no purpose or substratum at all, or, if it did, it was essentially to hold funds for whomsoever YC and YT Wang might choose in the future. And therefore, the purpose of the trust was entirely ambulatory in that respect until that choice was made. With the purpose of the original gift firmly in mind, the second step is to analyse the relevant powers which were given to the GRT trustee, the relevant powers being a combination of the powers to add and exclude objects of the discretionary dispositive powers and the trustee's dispositive powers themselves. And after those analyses, the purpose of the original gift, having that in mind, the purpose of the powers that are given, asking the question whether, objectively speaking, it can be said reasonably to have been YC and YT Wang's contemplation at the time the GRT was created, not 4 years later, at the time they created the trust, that those powers could be used to destroy their original gift. So to look for the purpose of the original gift, so as to be able to analyse the powers properly, one needs to consider the GRT trust deed, and one considers that in our submission as a whole. What one can't and shouldn't do is to isolate out of it clause 8, which is the power of addition and exclusion of objects of the dispositive powers, look at those in a virtual vacuum and say, well, it says any, you can add any person, and any means any, and so that's the end of the matter. As Lord Justice Peter Jackson said in the British Airways case, which is at page 2046 of the bundle, it's paragraph 116, he said there that the question, therefore, is what is the purpose of the power of amendment in the context of the purpose of the scheme as a whole? In the first place, there must be an understanding of what is meant by the purpose of the scheme. And he then went on to determine that the purpose of the scheme in that case, the pension scheme, was not just to provide pensions. That was the result for which purpose it existed, but it was also to provide the essential means by which the pensions were to be produced. One sees that from page 2046 and following of the bundle, i.e. the purpose of the scheme was to provide pensions and the machinery by which the pensions were provided. And one sees that after that analysis, he goes on to say at paragraph 121 on page 2047,
you're taking us to this case now, are you?
Yes, please, my lord. So page
2047, thank you.
Yes. There one finds paragraph 121, and 4 or 5 lines down, he says, but there is nothing to suggest that the power of amendment was intended to give the trustees the right to remodel the balance of powers between themselves and the employer. In my view, the amendment to Rule 15 resulted in a scheme which was with a different overall purpose, in which the trustees effectively added the role of paymaster to their existing responsibilities as managers and administrators. And while we're in the case, perhaps it's worthwhile picking up para 122, page 2047, where he says, it is no answer to this to say that the power of amendment is framed in general terms and contains safeguards in requiring proper trustee-like behaviour, the taking of advice and the achievement of a supermajority. These are brakes on the power of amendment, but the question here is not whether the brakes are working, but whether the journey itself is permitted. And we say essentially that encapsulates the issue in this case, or the first of the issues in this case. So the starting point, we say, is plainly to identify the purpose of the trust as a whole. And this brings into sharp focus a fundamental difference between our case and the respondent's case, because we say that the purpose of the GRT was to provide benefit to YT and YT Wang's family members, because that's what it says. Whereas the Court of Appeal said, and Grand View say, that the purpose of the GRT was simply to create what they describe as a maximum flexibility trust. I think what Professor Smith has described as a massively discretionary trust. They say the purpose of which was to benefit whoever YC and YT Wong chose in the future should benefit. We say the purpose of the GRT, being to benefit family members, is clear from its terms and indeed is accepted by the respondents, which admits in its defence that the GRT was for the benefit of the children and issue of YC and YT Wang. The reference for that, for your lordships and your ladyships note, is page 311 of the bundle, where you find paragraph 9 of the defence, which responds to paragraph 7 of the particulars of claim, which is at page 301. It's also confirmed by Grand View's own evidence filed on this summary judgment application. One can see that, and perhaps we could turn it up very quickly, page 441. Where we find paragraph 30 of Susan Wang's affidavit, and you see from paragraph C that she says that in addition to the Wang Family Trust, it was, and this was at the time of the creation of these two trusts, which were created at the same time, it was now being proposed that the proposed beneficiary trust be established, and that although the planning of this trust had not yet been contemplated, it was envisaged that it should be for the benefit of the children of the founders, it being understood that their children would serve as directors of the Wang Family Trust. So, and yet, what we have here is a decision of the trustee to add Grand View and exclude all others, and to point out to Grand View and that decision being made in the best interests of the Wang Family Trust, not in the best interest of the beneficiaries of this trust, or the best interests of the Wang family members. And one sees that from paragraph 48 of the same affidavit. And indeed, that decision being made in the best interests of the Wang Family Trust when the Wang Family Trust was not a beneficiary of the GRT nor an object of the powers of appointment, advancement or resettlement. And that decision was taken specifically in order to prevent members of the Wang family from benefiting from the assets of the GRT. One sees that in the same affidavit if one travels through paragraphs 46 and 48. So if I may, could I ask your lordships and your ladyship to turn to the GRT trust deed, page 364, to analyse its purpose. And as your lordships and your ladyship knows, the factual backdrop, the factual context to this trust includes the fact that at the same time as this trust was being created, the Wang Family Trust itself was being created. Indeed, they were declared on the same day. And one sees on page 365, recital A, that this trust was to create, this is the GRT, was to create a private express trust. And that can be usefully compared to recital A in the Wang Family Trust itself. One just flicks over to page 381. That's where one finds the recitals for the Wang Family Trust, which recital A, that one is to create a trust for certain charitable and non-charitable purposes. So we've got a very distinct difference between the purpose of the GRT as described in the recitals and the purpose of the Wang Family Trust, which was a purpose trust.
Can I just ask, because you've mentioned it, can we just be clearly given the position in relation to non-charitable purpose trusts? I'm assuming that in Bermuda they are valid, but it's no doubt some statutory reference that we need to confirm that. If you could perhaps give us that at some stage.
Certainly, my Lord. It's provided for in the Trust Special Provisions Act of 1989.
Thank you.
That's right, isn't it? And that is at page 8385. 8385.
Thank you.
And as your lordship identifies, that specifically makes valid, effectively, a trust for a non-charitable purpose, which at common law, of course, is invalid. Your lordships and your ladyship also can see from the objects of the GRT, the company, which was to be the trustee and indeed declared the GRT as trustee, its corporate object was to act as a trustee of personal express trusts, the reference for which is page 623. So its corporate objects weren't to act as a trustee of purpose trusts, but to act as a trustee of personal express trusts. That's page 623. Then back in the GRT trust deed itself at page 365, clause 1 sets out the definitions, as your lordships and your ladyship sees, and all of the definitions are subject to the rubric at the top, which is wherever the context permits. The following definitions and rules of construction shall apply. And the first definition is beneficiaries, and you're sent straight to the second schedule for what beneficiary with a capital B means. The second schedule is at page 376, and it says that the beneficiaries shall, subject to the exercise of the powers conferred upon the trustee by clause 8, mean the following persons now living or hereafter born before the expiration of the trust period: the children and remoter issue of Y.C. Wang and the children and remoter issue of Y.T. Wang. So that's the definition of beneficiaries. And that is, as my learned friends will be swift to point out, of course, subject to the exercise of the Clause 8 powers, with the power to add and remove from that class. But what Schedule 2 does not say is anyone in the world except for the trustee. It says issue, children and remoter issue. But the effect of learned friends' arguments are that the words effectively subject to the exercise of the Clause 8 powers turn this into a definition which essentially says anyone in the world except for the trustee. But it isn't that. Then back to page 366 of the definitions of company, deed, initial property and minor, one has a definition at 1.6 of person. That's page 366. And that includes any individual, company, partnership and unincorporated association and any person acting in a fiduciary capacity. And that definition is material to the true construction of Clause 8 because the power is to add any person to the class of objects of the discretionary dispositive powers. So it's worth making 2 points whilst looking at the definition of person. The first is that it does not expressly include purposes, notwithstanding the fact that objects, we will see referred to a feature in Clause 9, and charities feature in Clause 6. Neither purposes, objects, nor charities feature in the compendium of entities under person. The second point is that it, like all the definitions, is qualified by the words wherever the context permits. So when we see the person, the word person in the trust deed, we have to ask the question, does the context permit it to have one of the, or more of the meanings ascribed to it in that definition? One sees that the very first time it is used, if one flicks over to page 367, is in clause 1.14, where it is provided that reference to the issue of any person shall include children and remoter issue and so on. So plainly there, the context does not permit the reference to person to be anything other than an individual. And the same can be said of other terms in the trust deed where the word person is used. And you have those set out in our case at paragraph 77, page 1780.
Could I just ask a very quick question? The $100 initially put into the trust, where did that come from? Presumably, was it the shares, the subscription monies for the shares in the GRT company?
No, my lord, the $100 was a note. It was a $100 note. It is said to have come from the GRT itself. So for the subscription for the company, I'm so sorry, my lord, yes. That is probably right, but I'm not sure that the evidence is there to answer the question. But
right. So we don't know where that $100 originally came from. Is that what you're saying?
I think on the evidence in this application, that's the position.
Right.
The grid shares are the substance of the contents of this trust. They were introduced by YC and YT Wang through Mr. Hung.
When you, I'm sure you'll come on to this, but when you say through Mr. Hung, were they not his shares beneficially?
No.
So he held them, he was given them on trust for the founders and then put them into this trust. Okay, all right, thank you.
Yes, I mean, there might be some issue as to exactly the terms on which he held the shares, but I think it is, it's not in dispute that the value of those shares effectively belonged to YC and YT Wang, certainly came from them.
Right, I mean, saying come from them.
Well, yes, my lord.
Is rather imprecise.
It is.
Who, presumably Mr. Hung had the beneficial ownership of those shares at the time that they were put into the GRT. Is that right?
I can't quite remember whether he had the legal ownership or just the beneficial ownership. Some shares were held by him having the legal ownership, so he was the shareholder on the register.
Right.
Others were held by corporate nominees on the register for him. And then they were held by him either for YC and YT Wang, which is what we say, or at YC and YT Wang's direction. And I don't think there's any dispute about that.
All right, thank you.
So clause 1.10 then defines the trust fund, and as your lordships pointed out, it's the initial property is the $100 with which it was settled, and the addition was made by the grid shares being transferred in at the direction of YC and YT Wang. And clause 1.10 anticipates additions being made, because it's not, the trust fund isn't just the initial property, but it's property that's accepted by the trustees as additions. And indeed, the clause 11 of the GRT specifically incorporates the powers which are contained in section 4 of the Trust Special Provisions Act 1989, which is at page 1974. And clause 4 specifically permits the trustee to receive property from any person as an addition to the trust fund. So the GRT was a trust where additions were expected from YC and YT Wang in the form of the grid shares, and in relation to which additions could be made pursuant to its terms. So it was perfectly possible for others, for example, the founder's children, to have transferred funds into this trust as an addition to it if they had so wished. So the fact that others were anticipated to contribute to the settled funds of the GRT is not a feature which distinguishes the GRT from the case of Ray Dyer. That's the case in which a trust fund was created to fund an orchestra, but that's the basis on which my learned friends seek to distinguish that case. Going back to the GRT trust deed, after naming it and giving it a proper law in clause 2 on page 367, the scheme of the deed is then that clauses 3 and 4 set out discretionary dispositive powers of one sort or another. Clauses 5 and 6 declare the actual trusts essential to make the trust valid, and those actual trusts take effect at the end of the trust period. And clause 7 and following are administrative powers, powers which are there, we say, to assist the trustees fulfill the trust purposes. So the trust purposes we say are to be drawn from the trusts which are declared in clause 5 and the dispositive powers contained in clauses 3 and 4, all of which on creation are for the benefit of YC and YT Wang's issue. So looking at clause 3 in a bit more detail, that's a power of appointment. That's a power where the trustees shall, during the trust period, so it's during the trust period only, hold the trust fund and the income thereon on such trusts in favour of or for the benefit of all or any one or more exclusively of the other or others of the beneficiaries in such shares or proportions, if more than one, with and subject to such powers and provisions for the advancement, maintenance, education or other benefit, or for the accumulation of income, administrative powers, discretionary or protective powers and trusts as the trustees in their discretion appoint, provided that the exercise of such powers is subject to the applicable rule governing remoteness of vesting, has to be by deed, exercised during the trust period, and it doesn't invalidate any prior payment. So For example, that power would be used if the trustees wanted to declare that they held a portion of the fund on trust to pay the income to YC and YT's children for their lives. The effect of the exercise of a power of appointment like that is to insert new trust provisions into the GRT. The funds don't leave the GRT. They are simply held on the terms appointed, and those terms must be for the benefit of one or more of the beneficiaries and necessarily can't infringe the rule against remoteness of vesting because they only take effect during the GRT's trust period. So during the life of the GRT only. Now, whilst the GRT trustee purported to exercise this power in transferring the entire trust fund to the Wang Family Trust, the transfer cannot realistically have taken effect as an appointment under this power, we say, because the funds left the GRT and the GRT was wound up after the transfer, no longer existed. So the funds did not in any sense remain subject to the GRT after the transfer. Clause 4 is a power of advancement. It is it's in default and subject to any appointment under Clause 3. The trustees may, during the trust period, pay, transfer, appropriate or apply the whole or any part of the capital or income of the trust fund to or for the maintenance, advancement, education or other benefit of all or such one or more exclusively of the other or others of the beneficiaries in such shares and manner as the trustees shall in their discretion and without being liable to account for the same think fit. And they've got power to accumulate. Now, a power of advancement is a power to advance a beneficiary's receipt of an entitlement under the trust. So he or she is given the trust funds earlier than he or she would otherwise get them. It's therefore no surprise, we say, to discover that the objects of this power of advancement have a future entitlement to the trust property, because the Schedule 2 beneficiaries, who are the objects of this power of advancement, are the issue of YC and YT Wang, and the issue of YC and YT Wang are also the beneficiaries of the trust, who have a future, albeit defeasible, entitlement to the trust fund. These...
Because they're the ones named in Schedule 3.
Those are the ones named in Schedule 3, the trusts named in Schedule 3, which is triggered by Clause 5. Exactly so, my lady. So these objects of these dispositive powers, beneficiaries with a capital B, have no proprietary interest in the trust fund at all. They have a mere spes. They have a hope that the trustees one day may exercise its discretionary dispositive powers in his or her favour. Clause 5 is where the trusts are actually declared, and it's headed Ultimate Trust, and it's subject as aforesaid, so it's made subject to an exercise of the dispositive powers. The trustees shall, at the expiration of the trust period, hold the capital and income of the trust fund upon the trust set out in the third schedule. As my Lady Rose has just pointed out, those are the third schedule beneficiaries, and the trusts of the third schedule are set out on page 377. And one can see, just glancing through it, that the beneficiaries of that trust are the issue of YC and YT Wang. And some terms are put around what and how they're to get the funds. So they are the people in whom the beneficial interest of the funds vest. They don't vest in possession because they don't get those funds until the end of the trust period of 100 years. And they may not get their entitlement because their entitlement could be defeated, for example, by the exercise of the Clause 4 power of advancement in favour of one or more of the objects of that power. Clause 6 then provides for basically Armageddon, because it says essentially if there are no issue at the end of the trust period, Then the trust is for charities chosen by the trustee. And as I mentioned earlier, charities weren't mentioned in the compendium of entities included in the definition of person. So this trust only arises if all issue have been wiped out. And in that eventuality, absent clause 6, the trust assets would result to the settlor's estates. Because it's 100 years on, they inevitably will be dead, as will their parents and siblings, and by definition, all their issue will be too. And so what would happen in that instance is that the assets would go bona vacantia to the Crown. And so this clause is put in to make the choice between the Crown or what the settlors chose, which was charities instead.
But charities would have to be persons, wouldn't they?
They wouldn't have to be, my lord.
I mean, how,
there could be some.
I appreciate the concept of charity is not a person, but a charity necessarily is a person, either trustees or a company.
Or a company, yes, indeed.
I think charities are within the definition of person, provided they have legal personality.
Well, the point that I made earlier was that they weren't expressly put there. Whether or not they're included in the definition is perhaps a different point.
What is your position on that? I think Sir David's asking you for an answer.
Well, may I come on to that? Because I will come on in the context of Clause 8 as to the meaning of...
Well, as long as you cover it at some time.
I'm very grateful. So where we get to, my lords and my lady, is that the YC and YT Wang's issue are the beneficiaries of the trust properly so called, the people in whom the beneficial interest of the trust vests, and they are also the people for whom the trust fund, and they are also the beneficiaries with the capital B, in other words, the objects of the powers of disposition. And that's an important distinction which Professor Lionel Smith makes in his article, which I would commend to the board, particularly on this point at page 2958. But 4 points we say are worth making at this point. Firstly, the existence of beneficiaries entitled to the trust fund, in our case that's the Schedule 3 beneficiaries, is vital to the existence and validity of the trust. A trust can't exist without them. The Lordships and your Ladyship will be familiar with Lord Justice Millett's much-quoted statement in Armitage and Nurse that there is an irreducible core of obligations owed by the trustees to the beneficiaries and enforceable by them, which is fundamental to the concept of a trust. If the beneficiaries have no rights enforceable against the trustees, there are no trusts. And it follows that if there are no beneficiaries to whom the trust fund must go, absent an exercise of discretionary powers, there is no trust. All there is a resulting trust for the settlors. So there's an important but often overlooked distinction between beneficiaries, properly so called, and objects of powers of distribution. A trust can exist without there being any discretionary dispositive powers, and therefore can exist without any objects of such powers. A trust cannot exist without beneficiaries, or rather it just exists as a resulting trust for the settlor. And that important distinction is made, or rather the Privy Council authority of Vatcher and Paul, which is cited in our case at paragraph 35, page 1764, and itself is at page 2493, and the passage that we cite is at page 2500. That, we say, is authority for the proposition that the ultimate trusts declared embody the primary intention of the settlor, and that any power of appointment which defeats those trusts must be exercised bona fide for the purpose for which they are given, and that the ultimate trusts embody the intention of the settlor, and the purpose of the trust in our respectful submission, is absolutely right, and the Court of Appeal in this case was wrong to dismiss the beneficiaries of the ultimate trusts as basically an irrelevance. Lords, the fourth point that I would make in relation to this is that there was no power to add or subtract from the class of ultimate beneficiaries. We'll see in a minute that Clause 8 is specifically directed at beneficiaries with a capital B, in other words, the Schedule 2 people, the objects of the discretionary dispositive powers. Now, my learned friends say, well, that's not right. There is a power to change the ultimate trusts because that can be done under the Clause 3 power of appointment. But we say that's not right because that power, as we've just seen, is a power about creating trusts which sit under the umbrella of the GRT and only sit there during the trust period. It can't be used to change what happens at the end of the trust period. And what my learned friends cite in support of this proposition, that the Clause 3 power of appointment can be used to change the ultimate trusts, is Blouston and the IRC. But Blouston is not authority for that proposition at all. In that case, and one can pick it up from page 4150 in the bundle.
Page
4150.
Thank you.
The trustees exercised a discretionary power of appointment. You can see that on, I think, page 4150, to appoint funds only during the trust period to be held on the same trusts as were declared in the settlement, but with the omission of the wife or widow as an object of the discretionary powers of appointment. And one sees that between letter A and B, I think. As Lord Justice, the ultimate trust, one sees at page 4150D, was left untouched. And as Lord Justice Buckley said at 4151C to D, the appointment only operated during the trust period, and its only operative effect was to remove the wife from the trust of income and from the class of objects of the discretionary powers of appointment. So my learned friend's submission, which is on paragraph 84 of their case, page 1889, that Blouston is authority for the proposition that an appointment, a power of appointment, can be used to alter the ultimate trust. So, for example, to put the British Heart Foundation in place of the third schedule trusts is just wrong. Indeed, if it were right, there would be no need for any trust to contain any power of amendment if it had a power of appointment at all, let alone a power to add or subtract from the class of objects. They also cite the BVI case of the New Huerto Trust, which is at page 6891 of the authorities. That's not authority for the proposition either. It was also a case where a discretionary power of appointment was used to exclude the settlor as an object of the power. It says nothing about the alteration of the ultimate trusts. And we certainly say that an administrative power of amendment could not be used to achieve such a result either. You have that in our case at paragraph 36.2, and the case is in footnote 36, which include the Duke of Bedford and Abercorn case. My learned friends say, well, yes, it could, and they cite two authorities for that proposition. The first is Kearns and Hill, at page 2572. But the problem with that report is that it doesn't identify what the ultimate trusts in that case were at all. And therefore, it is certainly not authority for the proposition that the ultimate trusts can be amended by an administrative power of amendment. The second case they cite is the permanent trustee case at page 8415. And that was a scheme to transfer the interests of unit holders in a unit trust to shares of the company, which was going to hold the same asset. So it was a transfer of apparatus through which the assets were held and the unit holders held their interests. And the powers of amendment were subject to resolutions of the unit holders. And again, it is simply no authority for the proposition that ultimate trusts in a trust for beneficiaries can be amended by a general power of amendment. Now, what the Court of Appeal decided and my learned friends submit is essentially what you do is ignore the beneficiaries of the trust, who they have to be there because otherwise the trust isn't valid, but you ignore them because the ultimate trusts are never intended to arise, and the true beneficiaries of the trust are therefore not ever intended to benefit. Instead, the trust in reality, although not in form, exists for the benefit of the objects of the powers of appointment, they say. They are the primary objects of the settlor's gift, and you also ignore the fact that there are specified objects of those dispositive powers because the power to add and exclude add to and exclude from that class trumps all of that and is the guiding light in the true determination of the purpose of the trust. And that's how they get to the submission that the purpose of the trust is really a purpose to benefit anyone in the world, save for the settlors, whom the settlors choose in the future, or whom the trustees think the settlors would have chosen had they been still alive. And this, they say...
How does that qualification come in? The power under Clause 8 says what it says. There are certain people who are excluded, but what is it that requires the trustees, when exercising the power in Clause 8, to have any regard to the wishes, however expressed, of the founders who simply added the money? Could they not have added in someone, obviously not themselves or their creditors, but some person that they chose without regard to the wishes of the founders?
Yes. Yes, they could. But
it wouldn't be a breach of trust for them to
ignore that. I mean, take a more extreme example. Let's say the settlors who were still alive. It's not far from this case.
The settlors, the founders.
The founders.
Yes,
you're quite right, my lady, because they didn't. Strictly speaking, they didn't settle the trust.
Yeah.
So the founders said to the trustees, we'd like you, please, to exercise your discretionary dispositive powers in order to give all the funds to the local Taiwanese takeaway. We would submit that if the trustees simply did that, they would be in breach of trust, because what the trustees have got to do is work out what the extent of their power is, first of all, and we would say that that would fall outside their power, and because they've got to look at what the purpose of the trust in the first place was. And if the settlers were asking them to do something inconsistent with the purpose of the trust,
yes,
then they're not empowered to do that.
Now, I was looking at the different situation of the trustees themselves deciding to give all the money or some of the money to the local takeaway, even though the founders say, no, we don't want you to do that. And they say, well, you've given us all these powers. That's what we're deciding to do. Is it only your purpose constraint that stops that from being a breach of trust?
Well, we would say that they don't have power to do that at all, because the powers invested in them don't extend that widely, because they're doing something that's out with the purpose of the trust.
Yes, I
Well,
know.
that's in a sense you're agreeing with
Yes.
Lady
Yes.
Rose, I think.
My Lord, I think that's probably right. It was the breach of trust point that I was perhaps not quite agreeing with.
Right, but if the respondents are right that there is no constraint on the Clause 8 power, and the trustees can appoint anybody they like, subject to the exclusions, then there's nothing to stop them from appointing anyone they like, even if the founders disapprove of that. Is that where it gets to?
Well, my Lady, I think that's probably right in terms of the extent of the power. I think what my learned friends would say in relation to that is there is, of course, the duty of due deliberation. So they have to think about it properly.
Yeah.
But if having thought about it properly, they still take the view that actually that's what they should do with this money, then there is nothing, on their case, there's nothing to stop them doing it.
Yes, and then does thinking about it properly, as you said, to what extent does that involve taking account of abiding by the wishes of the founders who have alienated this property?
They have. They've given it away. It's not theirs anymore.
Yeah.
Absolutely right. Their wishes expressed at the time of the creation of the trust may come into the due deliberation process. It's something that can be taken into account. But the extent to which a settlor can say later on, well, I've changed my mind entirely, and whilst I set this trust up for my first family, I've now actually taken up with someone else, so I want to get rid of them, and I want this trust now for my new wife, it is perhaps a moot point. Many would say, I think that's the trustees can have regard to it, but having had regard to it, if they say, well, no, that's not what this trust was set out to do, so I'm not going to do that, they would be perfectly right to take that course. So this is what my learned friends call the modern a modern discretionary trust. It's a trust of maximum flexibility, they say, but we say that those submissions turn the fundamental importance of beneficiaries of a trust, properly so called, on its head and do not accurately reflect the law. Professor Lionel Smith describes such trusts as massively discretionary trusts in his article, a full reading of which we commend. And if one looks, and it starts, I think, at page 2956, if one simply looks at page 2963, at the top left, in the left-hand column, he says, these are what I mean by massively discretionary trusts. Trust structures in which the trustees' dispositive discretions do not merely qualify the beneficial interests, but effectively displace them. One might say, overwhelm them. And then 2970, at the in the bottom left, he says that the default beneficiaries must be a real beneficiary. The only alternative is that there is no trust, either in the wide or the narrow sense. As Lord Justice Millett said in Armitage, if the beneficiaries have no rights enforceable against the trustees, there are no trusts. He was not talking about the objects of powers. And he describes massively discretionary trusts, 2978, bottom right. That's the wrong reference, apologies. Final paragraph at the bottom right of 2978. In fact, if one can see from the top of that column, he says, and it picks up my Lady Rose's point, the wishes of the settlor take on a dominant role, so much so that the structure seems to be a kind of purpose trust. If it were found that the genuine intention of the settlor, shared by the trustees, was that the trustees should implement the wishes of the settlor rather than act in what the trustees perceive to be the best wishes of the beneficiaries, then there is a serious risk of a finding of invalidity and hence resulting trust.
Should that mean interests, best interests of the beneficiaries?
Yes, it must do. It must do.
Yes.
Lord, yes. And then in the next paragraph at the bottom of that page on the right-hand column, he describes the risks having in common, in my view, is that massively discretionary trusts are a kind of deformation of the trust device. And over the page at 2979, he carries on describing those, but in the right-hand column, bottom left, he essentially says that a settlor who wants to create a structure in which his wishes are controlling, but are at the same time not legally binding, so that they can be variable and secret, has misunderstood the nature of the trust. So the use of the trust institution on which my learned friend's submissions are founded, where the actual beneficiary is not intended to benefit at all, they say, and those who are intended to benefit from the exercise of the powers of appointment are not identified in the trust deed. So, for example, a classic Red Cross trust, where the only identified object of a discretionary power is the Red Cross. And similar to the trust that Hyman Sofer established in the case at page 5327. He was a South African businessman who wished to get money out of South Africa. He went to some lengths to ensure that he and his family were not named as beneficiaries or objects of the powers of appointment in the trust deed. We say those sorts of trusts are essentially and actually an abuse of the trust institution, which firstly subverts one of the foundational pillars on which the law of trust rests, namely the beneficiary principle, a requirement that there is a beneficiary with a real vested interest who can enforce the terms of the trust. And secondly, allows the existence of a trust which in reality is for anyone in the world who the settlor wants to choose in the future, when if the trust deed actually said that the trustees hold the fund on trust for anyone in the world except for X, that would be a void for administrative unworkability on the test set out in Baden No. 1 by Lord Wilberforce and picked up in Ray Hay's settlement. And those cases are at page 4826 and 4934. And the example given by Lord Wilberforce in the Baden case is a trust for the benefit of all the residents of Greater London, as the trustees may choose. He says that would be administratively unworkable.
So is your submission that if the other side are correct, there is actually no valid trust at all?
Well, my Lord, it would have to go as far as to say that the actual trust for the beneficiaries, the Schedule 3 trusts, are a sham. But they get very close to that because they say that that trust was never intended to take effect. But if the position was that that trust is a pretense and the real beneficiaries are the class can be anyone in the world except for X, and that's the real trust, then yes, that would be void. But there's a distinction to be made between
So you are taking the view that what Professor Lionel Smith calls massively discretionary trusts are not trusts at all?
Lord, it depends, because there is a beneficiary in them. So, for example, a massively discretionary trust will often have the Red Cross as the beneficiary, the ultimate beneficiary. So there is a beneficiary, But if what's going on, really going on, is the Red Cross is never intended to benefit, and the trust is a trust for anyone in the world except for X, and it's a trust for that, that would be void. But one has to be a little bit careful because there is a different test on administrative unworkability for powers of appointment. So a power of appointment in favour of all the residents of Greater London would not be administratively unworkable. But a trust for the same class would be. And the difference being that a power does not have to be exercised, and a trust does.
But I think what you're saying is that if you don't have beneficiaries, then there's nobody who can enforce the fiduciary duties of the trustee. So the Red Cross is not going to come thundering in to say to the trustee, oh, wait a minute, you had a conflict of interest. And in fact, you have appointed yourself or one of your creditors, that in the absence of a beneficiary, there's actually no practical constraint on the conduct of the trustees, except, I suppose, can they be removed by the protector, or
only if there is one. And in this trust, there isn't one. There is.
Oh, yes, I thought there was a committee.
Of course, yeah, that's absolutely right. There is one, but not in all trusts is there a protector. So relatively modern.
Right, but the protector can't bring proceedings for breach of trust.
No, I don't think so.
No.
So can anyone bring proceedings for breach of trust where you've got a discretionary trust of this sort? Supposing the trustees do something absolutely outrageous.
Yes.
Who can bring them to book?
The beneficiaries, properly so called, so our Schedule 3 beneficiaries.
Just remind me, but aren't they people living in 100 years' time?
Well, they...
How would you ever prove as a claimant you were within that class?
But you've got it's the issue and children of YC and YT Wang.
I mean,
so although that's a vested interest, although it's a future one.
Yes.
And so you are a beneficiary, even though the likelihood of you actually getting anything, because it's 100 years' time that it will vest in possession, might be remote. But you are the person who can call the trustees to book.
Right. I see. So the definition of in Schedule 3 is the people who fall within that are the issue from time to time, but it's only the ones who are alive in 100 years' time who will actually get the money. Is that right? So they can, from time to time, enforce that. But if it's the Red Cross or the junior partner of Freshfields, then...
Well, they may not even know.
They may not even know.
But yes, I mean, just to finish the children and issue point, each of them, if you're a child or remote issue of YC or YT Wong, you have a vested interest, but it's a future interest.
Could you just give us the page reference for Schedule 3, please?
It's 377.
Thank you.
So you have a vested interest, although it's a future interest, and it remains to be seen, therefore, whether your vested interest will vest in possession, which depends upon whether you are alive in 100 years' time.
The trustee shall divide the trust.
And the words in the third schedule, in default of, subject to the trusts, seem to have a tendency to suggest that actually the main trust is for the beneficiaries, i.e. those in Schedule 2, doesn't it? What do you say is the significance of in default of?
Well, that makes their interest not only future but also defeasible. Because if, for example, the trustees exercise their Clause 4 power of advancement to one of them, then the other beneficiaries, children at issue, future interest is defeated because there are no funds anymore if it's the entirety of the fund that's transferred out. So it's recognised that not only do these people have a future interest, but also one that's capable of being defeated by the exercise of the by the exercise of the dispositive powers. And there is also authority that the the objects of the powers of disposition can enforce the trustees' duties and responsibilities.
And just explain to me again how this point fits in to your framework. So you're saying that because it's essential to have beneficiaries, properly so called, because they are the ones who can keep the trustees to their fiduciary duties, the Court of Appeal erred in disregarding the identity of the beneficiaries when considering the purpose of the trust and hence the purpose for which the powers can be used. Is that how it works? Yeah.
Exactly. So what we submit is that the Court of Appeal were wrong to do that, and Malone and Friends' approach is not an appropriate approach on which to look at and construe the purpose of the GRT. And what the court should do is examine the purpose of the GRT and therefore the purpose of the powers conferred on the GRT trustee through the lens of the traditional well-established trust concepts and not through the lens which thoroughly abuses those trust concepts, which is the lens through which my learned friends invite you to approach this matter.
I think you said a moment ago that there is authority, that objects of the discretionary power can enforce the trustees' duties. If at some point you could give us those authorities, I'd be grateful.
Well, the main one is Schmidt and Rosewood.
I see. Right, thank you.
Do we have that in the bundle?
Yeah. Well, yes.
Sorry, that's authority for what proposition?
Objects of the power of appointment, of powers of appointment, have standing to enforce the trustees' duties and responsibilities.
Can you just help me on this? I'm just slightly confused as to the relationship on your submission between the second schedule and the third schedule. Why isn't it just sufficient for you to be arguing that the beneficiaries are those set in Schedule 2, in the second schedule? Why are we continually being taken to the third schedule on your submission for why that is the definition of the beneficiaries? I'm not quite sure I understand the exact link in your submission between the second and third schedule.
So what we say the trust does, as many do, is to declare a trust, and the trusts declared by this deed are those declared in Clause 5, which are the trusts which are set out in Schedule 3. So those people are the true beneficiaries with a lowercase b of this trust. The beneficiaries with a capital B, who are the people set out in the second schedule, are the objects of powers of appointment. And the difference between them is that the trustees are not obliged to exercise those powers of appointment and may never do so, whereas they are obliged to fulfil the trust, properly so called, which is the Clause 5 trust and set out in Schedule 3, which is why those people are the beneficiaries properly so called, with the others, the Schedule 2 people, being merely objects of powers, discretionary dispositive powers, which may or may not be exercised.
I thought your answer was going to be rather different. I thought the answer to my Lord Burroughs' question was more that the second schedule is capable of being added to by the exercise of the power in Clause 8.
Yes.
But the third schedule isn't.
Yes. But and that's absolutely right. But I wouldn't have said that that was the reason why we're going to the third schedule. The reason why we're going to the third schedule is to make clear
Yes.
the predominance of, we say, and Vatcher and Paul says, of the beneficiaries properly so called, because that colours and gives character to what this trust is, what the purpose of this trust is. In fact, here we have an identity at the outset of the objects of the discretionary powers and the beneficiaries.
But the reason why it's difficult for you to rely on the identity of the people in the second schedule as indicating the purpose of the trust is because that is flexible
Yes.
by the use of Clause 8.
Yes, well, that one leads one to the degree of flexibility
Yeah.
which is given by the powers which are given, and particularly the powers of addition and exclusion. Exactly so. So we do say that your lordships and your ladyship should look at the construction of this deed through a proper analytical, legal analytical approach, rather than looking at it as a massively discretionary trust, as Professor Smith calls them. And that is not only because that's correct as a matter of law, we say, but also because this wasn't a massively discretionary trust. This isn't a Red Cross trust. This isn't a trust where no beneficiaries appear on the face of the, or objects of powers of appointment appear on the face of the deed other than a charity at the end of the day. And so it very clearly doesn't fall into that category. Now, my learned friends say, well, these massively discretionary trusts are common, particularly in offshore financial centres. And we say, well, that's not the position today, and they are not encouraged by offshore centres. And you have that from the Guernsey Court of Appeal in Rusnano. If one goes to page 2109, sorry, it's in 2019, it's page 2684. Apologies. Where in paragraph 43, you see that the Guernsey Court of Appeal refers to what they describe as Red Cross trusts, and say, we have to say that we are not necessarily too discouraged at the possible effect on such trusts. We question whether they are as common nowadays as perhaps they once were, and whether they are to be encouraged in an international finance centre such as Guernsey with a high reputation for upholding international standards. And you also have it from Acting Justice Kawley in this case.
Well, and he goes on in 43 to distinguish massively discretionary trust from one where the beneficiaries are the children in remoter issue.
He does. And the question in the case was whether the object of a power to add a beneficiary could prevent the beneficiary from saying, under Saunders and Vautier, please hand over the trust fund. And the answer was no. And one also has the same sentiment being expressed by Acting Justice Kawley in this case at first instance, at page 63. I think it is. It's when he's dealing with his one of his examples. It's paragraphs. It must be paragraph 63. May I just find it with apologies? Page 90, I'm grateful to my learned friends. Apologies. Para 127.
I'm sorry, what are you wanting us to look at?
In the judgment of Acting Justice Kawley.
At which paragraph?
127.
127. Oh, I'm sorry. Yeah. Apologies, my lord, I was in the wrong document. So, page 90. No, it's not that. Perhaps it is. It was page 63 after all. I'm so sorry.
Oh, I thought, no, well, paragraph 127 is about the walls tumbling down, is it?
Yes, indeed. But the bit that I was, there's that, but the other bit that I was going to invite your lordship's and your ladyship's attention to is on page 63 in paragraph 74, it must be, where he's going through his case A and case B to show examples of the way in which he would have dealt with the matter. And under the hypothetical holding, just above paragraph 75, page 63, he would have found that what he sets out in that example falls outside the scope of the relevant powers, and says it would be contrary to the public policy of Bermuda as a reputable trust domicile to permit a settlor to obtain the tax benefits of an irrevocable trust, representing to the relevant tax authorities that he had permanently disposed of substantial wealth, and then simply change his mind later.
I'm so sorry, where are you getting that text
I must say, I've lost you. You've given us so many page
I know,
numbers.
it's entirely my fault.
So where do you want us to look at, and where do I find the quote you've just read?
Page 63.
Electronic 63.
Electronic 63, which is the judgment of Acting Justice Kawley.
Yes.
And just above paragraph 75 in the italics on that page,
Yes.
under the heading hypothetical holding, it's about 3 lines down.
And what is this italics thing? Is it a quote from something else?
No, lady, if one turns back a page and picks it up from paragraph 74, he summarises his legal findings by reference to 2 hypothetical scenarios. And case A is one hypothetical scenario, and how he would have, what he would have decided in that scenario, and case B is another. And that's part of the way in which he deals with it. But it's what he says about the public policy of Bermuda and being a reputable trust domicile.
That's the hypothetical is where the settlor wants to add himself as the sole beneficiary to avoid financial ruin.
Yes.
And he wants the money back.
Yes.
Rather colourful hypothetical case.
Yes, I mean, that is somewhat, that case B is somewhat removed from our present circumstances.
I suppose the analogy would be if the founders in the present case had requested that they be added as beneficiaries or objects, and then the matter proceed as it did.
Yes, indeed. I mean,
now, economically, at any rate, would be the equivalent of hypothetical case B.
yes. So it's, as you see from his judgment, it's not very far away from a total revocation of a trust that is unamendably irrevocable, so that settlors, that enables the settlors and the economic settlors, I'm so sorry, to say, well, it's not my money, it's nothing to do with me. But if at the same time they were effectively retaining the right to say, well, actually, trustees, I've changed my mind, give it all back to me, or actually, trustees, I've changed my mind, I don't actually want it back, but I want you to do this with it, he hasn't actually let go of the money in any real sense. And it's not right for him in those circumstances to say to the taxman, to his creditors, and perhaps even to a divorcing spouse, sorry, it's not my money. And that's the That's the point, I think.
But I mean, if he did ask for it to be appointed back to him, that might have all sorts of tax consequences in and of itself. I mean, it seems a little bit strange to say, well, there's a public policy against that, where the legislature would control what happened in that sort of situation.
Well, indeed, but if you retain, if say you didn't ask for the money back, but you were still directing what should happen to it effectively.
Well, if you had a power of direction, that might have all sorts of tax consequences.
Indeed.
But I thought everyone was agreed that it's pretty much common form that you get letters of wishes from founders and settlors in this sort of situation, and that doesn't change the nature of the trust, that they have fully divested themselves of the property, any property interest, even though they may hope that the trustee will have regard to their expressions of wishes.
Yes, but then it takes as Professor Smith set out in his article, if what one has is a trust which gives the trustee no clue as to how he's meant to exercise the discretions that he has, then the letter of wishes and even changing letters of wishes after the first one effectively become the only thing by which that trustee can, the only yardstick by which that trustee has to exercise the discretions that he's given. And so one actually goes across a boundary, in my respectful submission, at that stage.
Well, I slightly question that. Is it the only yardstick? I mean, acting bona fide for the purposes of the trust, if they have a sense, no more, uninformed by a letter of wishes, but they knew the settlor well, they have a sense of the sorts of things that he would have liked to have been done with the money, doesn't that give them something of a yardstick? Yes,
it does. I agree with that, my lord. But I think that the scenario that we're looking at here is the trust, when it's established, and let's assume it's for the Red Cross, the trust is for the Red Cross, and there's power of appointment in favour of anyone in the world except the trustees.
Could I, and I apologise if this is taking out of your course a little bit, I'm still puzzling a little bit over the terms of the trust deed at page 369, clauses 4 and 5, so perhaps 368. So you characterised clause 4 as a power of advancement, but I mean, it doesn't describe itself as a power of advancement, and it seems to be wider than just that. It's a power to accumulate capital, to do all sorts of things with capital. And then clause 5 is headed ultimate trust. So that doesn't seem to be the trust that applies during the life of the trust. When I first read this, I rather read that as standing in place of what would otherwise be a resulting trust, because this is a purpose trust. If nothing else was said, what happens at the end of the trust period? I would have thought that the law would say it's a resulting trust and the beneficial interests go back to the settlors or their estates.
Yes.
But clause 5 stops that from happening because it says, no, we're going to have a different ultimate trust.
Yes.
But if one looks at Schedule 3, on which you place so much weight, which is page 377, I'm just looking at the opening words. In default of and subject to the trusts and powers contained in clauses 4 and 5. So is that where there's the mistake that everyone agrees that's 3 and 4? Is that right?
Yes.
Okay. So, well, in a sense, that makes the point I was about to put to you even stronger. That makes it look as though the drafter of this instrument regards what they have done in clauses 3 and 4 as creating the relevant trusts and powers for this trust, with thereafter, if those things haven't happened, you're left in a sort of quasi-resulting trust situation, but it's the third schedule that then tells you what happens with the beneficial interests rather than just the general law of resulting trusts.
Well, the clause 3 power allows the trustee to create a trust under the umbrella of the GRT.
All right.
Because that's the power of appointment. So, for example, the GRT trustee could declare under clause 3 that it held the income from the assets of the trust on trust for the children. And that would be then a trust. So the way the trust is, the scheme of the trust is to create a mechanism by which trusts can be declared by the trustees under Clause 3 during the trust period. It creates a mechanism under Clause 4 by which the trustees can transfer the property out of the trust. And that's why the trusts, the ultimate trusts in Clause 5 and Schedule 3 are subject to the exercises of those powers.
So somebody who was within the Schedule 3 could not complain that it was a breach of duty by the trustee to appoint all the money to somebody else or to other beneficiaries. They couldn't say, oh, but look, we're the Schedule 3 beneficiaries, so we were supposed to get something out of it. The proviso that it's in default of the exercise of the powers in Clause 3 and 4 makes it clear that it's not a breach of duty towards the third schedule beneficiaries for the trustees to give the money to the Schedule 2 donees.
Exactly.
Appointees, yeah.
Exactly.
And if I may, just going back to the resulting trust analogy, I'm not sure that one would ordinarily say in a discretionary trust situation that it's really a trust for the settlor, because they will get the monies back on a resulting trust basis if the trusts fail. Would you?
I think that probably depends what your lordship means by a discretionary trust. If it was a trust for no one, but there were powers of appointment in favour of X, Y, and Z, then the trust would be, the settlor wouldn't have relinquished the assets, and the reason for that is that the powers may never be exercised. So the beneficial interest can't float around in the ether. Who owns the beneficial interest in the property that is held by the trustees? It's not the trustees. It's not the objects of the powers of appointment, because they only have a hope. It's the person that gets, the person who the trustees hold the property on trust for. And if there's no one, there is no trust. As Lord Justice Millett said.
Right. So is that as much as to say that actually you don't go through a resulting trust analysis, you just say that the whole trust mechanism collapses, that there's been no relinquishment by the settlor of the beneficial interest?
Well, I think you would probably say that he's invested in third parties, the trustees, are probably misnamed on this basis, the appointors, the power to appoint his funds elsewhere for a period of time. Right. But if they don't exercise those powers, who owns the trust property? He does.
Yes, I see. All right, thank you.
So the deed after clauses 5 and 6 moves on to deal with administrative powers. Clause 7, and that's on page 369, bestows a wide power of investment on the trustees. And clause 8 is then the power to declare that any person or class or description of persons be included as a capital B beneficiary. And because it's a capital B beneficiary, it's not applicable to the trust of the fund contained in clauses 5 and 6, because the capital B beneficiaries are the objects of the powers of appointment in clauses 3 and 4. We say it's important to see that power of addition and exclusion in its context, so in the context of the trust as a whole, and that the significance which my learned friends attach to clause 8.2, which provides that, which excludes the person who's exercising the power from being an object of it, they ascribe the significance to that because they say, well, if the category of people that were capable of being added was restricted, as you say they are, then you wouldn't need that provision in clause 8.2. But the answer to that is clause 8.2 is simply there to make clear that the power is a fiduciary one, and to avoid any argument over whether it's a fiduciary or a beneficial power. A beneficial power is capable of being exercised in favour of anyone, including the trustee, whereas fiduciary power can't be exercised in favour of the trustee or the appointor in this case.
The wording of clause 8.2 is rather odd, because the proviso applies to that they can't exercise the power in their own favour is a proviso that applies to such person, and the such person is not actually the trustees but anybody to whom the powers may be delegated.
Yes.
Yes.
But where is the limit on the trustees actually appointing their creditors, or is that just imposed as a matter of the general law?
Exactly.
Right.
So the trustees in law are not entitled to do that because they're trustees. If they delegate this power to someone else, nor is that appointer allowed to do that.
So you say that it's simply a clause saying that the delegate is subject to the same fiduciary duties as the trustees themselves.
Exactly. So it doesn't bear the significance that my learned friends seek to put on it. And then one has clause 9, which page 370, which permits the trustees to make a transfer to or for the benefit of a beneficiary, capital B, so in exercise of their powers under clauses 3 or 4, instead of to that beneficiary, to a trustee of a settlement for the benefit of such a beneficiary, notwithstanding that there may be other beneficiaries under that trust, or there may be objects under that trust that benefit. But it's got an important proviso, and that important proviso is that so that no such payment or transfer shall be made which would or might infringe any applicable rule governing remoteness of vesting. And we say that that important proviso is applicable to any transfer to another settlement. My own friend Mr. Hagan will develop that. And after that, one sees that other administrative powers, there's a general power to amend in clause 10, except from that is clause 23, which is the clause which provides the trust to be irrevocable.
But just going back to clause 9, I realise that your learned friend's going to develop that, but is it part of your case on that the transfer that took place must actually have been an exercise of the power in clause 9, even though it purported to be the exercise of a different power? Or do you say even if it was in fact the exercise of a power in clause 4, the proviso in clause 9 applies?
The exercise of the power itself would be either pursuant to clauses 3 or 4.
Right.
Clause 9 just says, if you want to use your clause 3 or 4 power to benefit a beneficiary, but you want to make the transfer to a trust of which that beneficiary is a trustee, that's okay. You can do that. But there's a proviso. And so it's honing in on and focusing on a distribution to another trust, and says where there's a distribution to another trust, you can only do that provided that the transfer does not or might not infringe, I've put that badly, but so that such payment or transfer shall be made which would or might infringe any applicable rule governing remoteness of vesting. No such payment can be made that would or might. So we say that's applicable to any transfer to another trust. And the reason for that is that the GRT trustee does not want funds boomeranging back to it at the end of its trust period when it thinks it's got rid of everything. Pausing on clause 14, you'll have seen from our case that the permission to charge remuneration is subject to an agreement between the trustee and the adult beneficiaries with a lowercase b, which we say is a reference to the Schedule 3 proper, true beneficiaries. And so it's those who are controlling or have the power to control the trustee's remuneration. And whilst clause 15, on which my learned friends rely, provides that every discretional power is absolute and unfettered, and that there are no need to give reasons for it. Of course, the trustees' powers and discretions are fettered. They are fettered by their fiduciary duties. And as was specifically said by the High Court of Australia and the Commissioner of Taxation and Bargwanna, a clause which states that, and the page number for that is 2513, and it's paragraph 13. They specifically say that a clause which states that every discretion and power conferred on the trustees shall be absolute and uncontrolled. They say the reference to the absolute and uncontrolled discretions and powers of the trustees should be read in the light of authorities which treat such apparently unconfined discretions and powers as not extending to alteration of the substratum of this trust. And the trust in case was for charitable purposes. We say that's an entirely accurate statement of the law in England and in Bermuda.
I've never quite understood. I mean, what this sort of clause means. They have a power of investment, but which is absolute and unfettered. Clause 15 says, but that can't entitle them to invest in something which is bound or almost bound to be lost.
Absolutely. Or in their own company.
Well, that perhaps introduces something else, because, but these are common words, but I don't know to what extent they've really been considered, apart from the Australian case you mention. I mean, it might be helpful to know if there are authorities which have focused on what that sort of common form wording is intended to convey.
Well, Lord, certainly, despite the wording, they are fettered.
Yes, I mean, they are fettered, and so the question, they clearly are, because there are equitable restraints on these powers. The question, therefore, against that background, is what these express words are intended to convey.
And, I mean, the same goes, one might say, your Lordship points out the power of investment, which is in incredibly wide terms, and also uses the word any investment. And so when my learned friends in the Court of Appeals look at the words of the trust deed and simply say, well, any means any,
yes.
That's rather...
It includes little nail on the 230, a toaster.
And there may be common law obligations as well to exercise reasonable care. So when one thinks of the duties of a director, they have fiduciary duties, but they also have a common law duty to exercise reasonable skill and care in the management of a company's affairs. And one would think, broadly speaking, a trustee would have a common law duty to exercise reasonable skill and care in the management of a trust's affairs. So, I mean, it's really just to extend my Lord's question. How does this sort of provision interact with those general duties as well?
Well, I mean, my answer to both your Lordships is it is an attempt, largely driven, no doubt, by trustees, to restrict their liability. It's done in two ways. This clause is one of them, to say, look, we can do what we like, which is not actually correct. And the other is by extensive exoneration clauses, which say that unless we run off with the money, you can't sue us, essentially. Clause 19, page 373, is worth just pausing over because it's a clause which excludes any benefit obtained from the GRT, from basically a marital community of property regime. And I pause on that simply to point out that that plainly envisages that beneficiaries with a capital B will be people who can marry, not trustees of other trusts. And it also provides that such benefit shall be and remain the sole, separate and exclusive property of such beneficiary. And so that doesn't envisage the property going to a trustee either, because the trustee isn't the sole, separate and exclusive owner of the property.
Is that a valid clause in a country where there is community of property? Anyway, that's just a...
Yes, I suspect that that would be a question of whether an order in another jurisdiction was enforceable against the trust in Bermuda. I think that's the way it would play out. If it had to be enforced in Bermuda, then no doubt that clause would be held up as rejecting it. And then one sees the irrevocability in clause 23, which we've seen clause 10 makes unamendable, which means that YC and YT Wang had, when they gave directed the shares in grid to be transferred to the GRT, they had given them away forever, without any ability to take them back if they changed their minds as to what they wanted to do with them and decided actually they wanted to do something else with them. And yet, on my learned friend's case, they preserved their ability to influence, if not dictate, what was done with the funds, which is, as Acting Justice Kawley recognised, is as near to taking the funds back to do something else with them as one can get. Because on the evidence which is assumed to be true but is not accepted, they told the GRT trustee of their wishes to take the funds away from the beneficiaries now and give them to something else entirely, and the trustees effected that wish. So one can see, having looked at the terms of the GRT, that it's not difficult to see that Susan Wang was right in her evidence when she said that the GRT was a trust for the benefit of the children at issue. We say of YC and YT Wang. We say benefiting Wang family members was the purpose, the substratum, the fundamental character of the GRT. So that then takes one to the application of the proper purpose rule to trustee powers, and the application of that rule to trustee powers leads, we say, to the substratum rule. And what my learned friends do in this regard, and the Court of Appeal did, is essentially make a bright dividing line between three challenges that can be made to a trustee decision. One is challenging it on the basis that it's an excessive execution, so what's done falls outside the power. Two is challenging it on the basis of inadequate deliberation. And three, they say, is proper purpose. And they say that the latter, proper purpose, doesn't affect the former, scope. That's in paragraph 12 of their case, page 1861 and following. They say you first have to ascertain the scope of the power, and only once the scope is fixed does one then address whether the power has been exercised otherwise than for a proper purpose. And they say that in dealing with proper purpose, what the court is concerned to determine is why the trustees acted as they did, not what they did. The issue is not with the outcome of what was done, but with the reason why it was done. We respectfully submit that such an approach is too blinkered and is wrong, as there is no bright dividing line between scope and proper purposes, with the proper purposes rule only becoming relevant after scope has been determined. We say that the scope of a power is affected by and can be limited by the purpose for which it was conferred. And so there are two separate and distinct ways in which the proper purpose rule has affected powers. One is to inform and limit the scope of the power in the first place. The other is to strike down acts which on their face are within the scope of the power, but which are intended to achieve a result which is beyond the purpose of the power. So, for example, making a distribution to X in order actually to benefit Y, when Y is not an object of the powers. In Eclairs, it was exercising a power which existed for the purposes of obtaining information about shareholders, for the purposes of removing a blocking vote to a resolution.
But, I mean, isn't that a classic case that there was no doubt about the scope of the power? Clearly, the shares could be frozen or taken away. The point was, what was the purpose? Equally, in a case like Howard Smith and Ampol Petroleum, the scope of the power was the directors had power to issue shares. The point was, for what purpose? So there was a bright line distinction in those cases, wasn't there?
Lord, yes, but as I understand my learned friend's submissions, it is that you don't look at purpose at all for the purposes of defining the scope, and that's where we depart.
Well, I don't think they probably did in either, did they, in Eclairs, and certainly not, I think, in Howard Smith.
But our position is that you look, in order to identify the scope of a power, you look at the purpose for which it was conferred. Because
you say that, but I'm just questioning whether that is actually what, for example, the Privy Council did in Howard Smith and Ampol Petroleum.
No, because you don't need to. Which is why I say the proper purpose rule has been used in two different ways. The second way is the Howard Smith way and the Eclairs way. Yes. But that doesn't mean there isn't a first way. I think that's
an alternative approach.
Absolutely.
So in Howard Smith, it could have been approached, you say, as a matter of, as it were, scope or construction of the power to issue shares. But instead, they chose just to go down the proper purpose route.
Lord, I think that the way that I would put it is that in defining the scope in the first place, you look at the purpose for which the power is given.
Well, is this right, that if there's an ambiguity in the wording as to how far the power extends, which there may not have been in Howard Smith or Eclairs, then, as with any exercise of construction of a statute or a contract or a trust, when you're working out what the words mean in the event of an ambiguity, or a number of possible interpretations, then the purpose for which the word is being used is one of the canons of construction that you can use.
Lady, we certainly say that's the position, and it's a way in which the proper purpose informs and defines effectively the scope of the power in the first place.
I wonder about that. I wonder if there isn't a bright line between the two concepts, but that you can say that in dealing with the first, the scope of the power, you can, as Lady Rose says, look at the purpose of the power as well as the individual words in ascertaining what its scope is.
Yes, Lord. I think my submission simply boils down to proper purpose is not excluded from looking at the power and deciding how extensive or not it is.
Well, I mean, is it proper purpose or at all? Because proper purpose is looking, I think, in Eclairs and Howard Smith, to the intention of the people in exercising those powers. Is it not? Yes. And what we're dealing with here is the first heading, the scope of the power, and what I think Lady Rose is putting to you, as am I, is that in an appropriate case, you look not just at the wording of the power, but the surrounding circumstances that give rise to a view as to what that power's purpose is.
Lord, yes. And the bright dividing line I was trying to make and say, actually, if you look at Pitt and Holt, from which they draw it, you can't take it from that, 2337. It is not between these two different approaches to purposes that we're discussing. It's between the three categories that they set out on which an exercise of a power can be challenged: scope, inadequate deliberation, and purpose. And they say that you look at scope first, and you don't, if it's not within the scope, you never get to purpose. And we say, no, purpose is actually part of defining what the scope is. That's where I think the difference lies.
And I'm just going back to your answer to my lady's question. I think my lady's question was, you only get into purpose if there's ambiguity in the language used. But I rather think you go beyond that. You don't say ambiguity is the trigger for it. It's something more fundamental.
Exactly. Because you've got to look at and that's why I started with the purpose of the trust, because that informs the purpose of the power, because the powers sit within a trust. They're there to assist the trustees fulfill the purpose of the trust. And therefore, the purpose of the trust informs what the powers are there for and what the trustees should be doing with them and what the trustees shouldn't and can't do with them. And I think that if we go to the Ray Dyer case, perhaps that will make the point better than I can. It's at 2655. And it was the case where there's a gift to a trust, gift on trust to pay the income for the maintenance of a Metropolitan Permanent Orchestra in Victoria. That's the case, 2655. And one sees from the bottom of 2656 that additions were, clause 3 we see, which is the power of amendment. That was given to the settlor, James Dyer, or his executors, a power to vary all or any part of the trust and powers him before declared and created.
Sorry, just give me that reference again.
Yes, it's 2656.
6, thank you.
And where on the page?
Bottom of the page,
Right.
where we see clause 3, about 4 lines from the bottom.
Vary all part of the trust. Yes.
So that was the power of amendment in question in this case. And what Mr. Dyer wanted to know, if one looks at 2657 from the court, is whether he could use that power to vary the trust so as to pay the income to specified musical associations. One sees that from the middle of page 2657, where 4 lines from the bottom of the second paragraph on the page, we see a draft deed was prepared, and that was the deed of amendment, and that's what it provided. And there was doubt as to whether the power was allowed him to do that, and so there was an originating summons to ask the court. 2658, it's recited in the middle of the page that Mr. Justice McFarlane held that the power didn't enable the settlor to effect those alterations. Despite the words being as wide as they could possibly be. There was a second attempt to come up with a second deed of amendment, but that fared no better either. So neither of them got passed as falling within the power of amendment. And then it went on appeal, and the appeal was actually dealt with on the basis of a perpetuity point. But at 2672, sorry, if we could pick it up at 2669, which is in the judgments of Chief Justice Irvine and Mr. Justice Gavin Duffy, they, after expressing doubts, 2669, 2 paragraphs up from where Mr. Justice Martin's judgment starts, having expressed doubts as to whether what was wanted to be done was within the power to vary. They agree with Mr. Justice McFarlane. The deed, however, they said, has to be read as a whole, and on consideration, we agree with the views expressed by Mr. Justice McFarlane, and they draw some support from the rules. But Mr. Justice Martin also agrees, and the relevant part of his judgment is on page 2672, halfway down the page, where he starts with another question argued before us, was whether the power to vary all or any part of the trusts and powers enabled the donor to execute any of the draft deeds which were exhibited. That was the only question argued before Mr. Justice McFarlane, and I deal with it, as he did, on the hypothesis that the trusts of the original indenture were valid. He sets out what they were and says it would be strange if the donor who desired help in founding a fund for a particular purpose and who expected others to contribute to that fund attempted to reserve to himself a power to change the whole substratum of the gift, not only as regards his own donation, but also the donation of others who subscribed money for the particular purpose. A power to revoke is common in deeds of this nature, and I cannot believe that the draftsman would not have included such a power had it been intended that the donor was to be entitled to benefit an object other than the one nominated in the deed. What are the limits of the power to vary is a very difficult question, which doesn't call for determination, but none of the deeds falls within those limits, and McFarlane J was right in holding that it was impossible to use the monies in such a way as will depart from the original purpose of the gift. So we say that this authority establishes the principle that a power of amendment does not extend to amendments which depart from the original purpose of the gift. And it establishes that the substratum of a trust is the original purpose of the gift into that trust. Now, my learned friends say that Ray Dyer does not establish those propositions for two reasons. One is because they say that the Clause 3 power in this trust, which we looked at, does not permit variations of the recitals. And it was the recitals which recorded the purpose of the trust in this particular case. And the second is, they say it was only decided the way it was because it was hoped that others besides the settlor would make gifts to the trust. But neither point we say is a good one. The first point actually makes our case for us, because they say effectively that it was found that there was no power to alter the operative terms of the trust if the result of the alterations was that the fund would be held for a purpose inconsistent with the purpose recorded in the recital. And the recital in this case recorded the purpose of the gift. In other words, we say that that is an acceptance that the case establishes that the amendment cannot alter the purpose of the gift. In this case, the purpose happened to be recited in the deed, but that doesn't matter. The principle, and the point that matters, the principle to be drawn from Ray Dyer, is that an amendment can't be made which departs from the purpose of the trust, the original gift. The second point that they make doesn't affect the point of principle that one can draw. The point of principle is not restricted to trusts where gifts to the trust are made by people other than the original settlor. In any event, as we've seen, others could make gifts to the GRT if they so wished, and YC and YT Wang did. Now, Mr. Justice,
you say that the founders are in the same position as the strangers to the trust who put money into the fund thinking it was going to be used for the building up this orchestra.
well,
I know it has a slight air of unreality about
Yes.
it, but then the whole of this structure has that's an air of unreality from which they take the benefit and have the burden as well.
Indeed. I mean, I don't shrink from the fact that when this trust was set up, it was anticipated that YC and YT Wang would direct the grid shares to be transferred to it. So that is, they weren't sort of complete third parties in that respect, and I don't suggest they were. But it is the case that the trust was set up with $100, and they did transfer assets in, and the trust provided for the trustees to accept additions to the trust fund from wherever they might have come. Didn't have to accept any such additions, but it could. And so I do say that the fact that it was anticipated in Ray Dyer that others would contribute to the same fund is not a point of distinction and not a point to mean that the points of principles that are set out there are somehow inapplicable to the GRT. Your Lordships and your Ladyship will have seen that Mr Justice Martin's language was borrowed with gratitude by Mr Justice McGarry in Ray Ball's settlement. That was a decision under the Variation of Trusts Act 1958, in which the court supplies the consent of someone who's unable to consent to themselves due to, for example, minority or capacity, to a variation. And the court was and is, in those cases, always anxious to see that what it is being asked to consent to is a variation properly so called and not a resettlement. And the reason for that is that Mr Justice Templeman had held in Ray T that the court's jurisdiction to supply the necessary consent was limited to cases of variation properly so called and didn't extend to cases of resettlement, because before 1958 the court had never had the power to consent to a resettlement on behalf of an infant. So that meant that the court in these cases has to look at the difference between variations and resettlements. And in determining that question, Mr Justice McGarry borrowed, after referring to Ray Dyer, and this is at page 4833, letter B, says that if an arrangement changes the whole substratum of this trust, then it may well be that it cannot be regarded as merely varying that trust. But if an arrangement, while leaving the substratum, effectuates the purpose of the original trust by other means, it may still be possible to regard that arrangement as merely varying the original trusts. And we say that that is instructive in terms of examining and construing powers of amendment in a trust, because we say that in just the same way that the court's power to consent to variations is confined to variations properly so called, a trustee's power to amend the provisions of the trust on which he holds the trust funds, including powers to add and exclude objects of dispositive powers, is confined to making amendments properly so called and doesn't extend to changing the whole nature or substratum of the trust. So that is not a variation or an amendment to the trust. It goes beyond amending it and goes as far as replacing it. And the powers that were conferred were simply not conferred for that purpose. And that analysis is unaffected by whether Mr Justice Templeman was right in Ray T to confine the jurisdiction under the 1958 Act, as he did. The point is he did so confine it, and the ways in which the court has therefore had to grapple with the difference between variations and resettlements is an instructive one. Hole and Garnsey is a decision described by Mr Justice Briggs in Stenerline and Merchant as the leading authority on the interpretation of powers of amendment, and that is to the same effect. That's the case of the Wilts and Somerset farmers and an amendment to their rule. If one picks it up at page 2139, one sees Rule 64, which was the relevant amending power, subject to a resolution of 3/4 at a special meeting. But there's no express limitation on that amending power. If you've got your 3/4 majority, you've got power to amend if you just look at the words. And one goes then to the speeches of Lord Atkin at 2159. which I think my learned friends for Grandview agree are the clearest statements of principle. And they also refer to Lord Tomlin. And one sees from 2159 that Lord Atkin puts the matter in terms of an inherent limitation on the power of amendment to matters which are within the scope of the venture as originally framed.
Where do we see this?
So, my Lord, I think
It's at the very bottom of the page, is it?
it starts at the very bottom of the page, my Lord, goes over to 2160.
I mean, if it's a clear statement of principle, please refer us to precisely where you see the principle stated.
Lord, I will.
I think it's the last sentence on page 2159, isn't it? If a man enters into association with others. At least that's the start of it.
That's the start of it.
But I mean, that, in one sense, does encapsulate the principle you rely on, doesn't it?
It does. And then if one travels through the pages, which I don't have, sorry to say, I don't have time to do, and goes to 2162, at the top of the page, says the only relevant question in this case appears to me to be whether Rule 64, giving the power to a three-quarter majority at a special general meeting to amend the rules, confers the power to amend those rules in respect of the fundamentals above mentioned so as to bind a dissenting member. I think that the consent of a member to such rule as Rule 64 is not an assent to have the purposes of the society or the amount of his share subscription altered against his will. Full effect is given to the rule by limiting its operation as against dissentients to matters which are within the scope of the administration of the venture as originally framed. And colourfully, Lord Tomlin, whose speech...
Just on that, it might it not be said that the context is quite different? It was a business venture. It was a sort of reciprocal arrangement between all the members. And what was being proposed was exercise of the power of amendment under Rule 64 to increase the subscription, the money they have to pay into the society.
Yes, but I mean, one might say, well, that's what they'd agreed to. Because they had agreed that if there was a three-quarter majority, then the rules can be amended. Okay. And what this is saying, we say, is that, well, there's a limit to the amendment power given by that rule, even if you've got your three-quarter majority. And that limit is you can't change the purpose for which the whole thing was set up in the first place.
Yes, right, thank you. As
Lord Tomlin colourfully put it, at page 2166, two-thirds down the page, he says there is, however, the second question, and poses the question and answers it in the negative, and says that in construing such a power as this, it must, I think, be confined to such amendments as can reasonably be considered to have been within the contemplation of the parties when the contract was made, having regard to the nature and circumstances of the contract. I do not base this conclusion on any narrow construction of the word amend, but upon a broad general principle applicable to all such powers. And so putting that into the trust context, its amendments should be confined to those that can be reasonably considered to have been within the contemplation of the settlor when the trust was made, having regard to the nature and circumstances of the trust.
So is that, the expression substratum is used, but ultimately what you're saying is what was in the reasonable contemplation at the time the trust was created. And that's assessed objectively, is it?
Yes, my lord. I mean, in terms of the purpose of the trust, that's where the substratum is. And when one's looking at the powers that are given in that trust, we say they're there to assist the fulfilment of the trust and the purpose of the trust.
But the purpose of the trust, when you speak about the substratum, again, you're looking to see what was contemplated at the time that the trust would cover.
Yes.
Well, yes, subject to this, that as you say, it's objective. So if there was evidence that the founders had said to the trustees, look, we need to set it up like this, but actually our intention is that you'll just do what we say for the next 100 years, that wouldn't, or that would be their subjective intention and therefore not included in what you construe to be the purpose. Would that be?
Well, I think it depends. Yes, if the trustees agreed that, you'd have a classic sham because the piece of paper doesn't reflect what's the actual position. If the trustees heard the settlor say that and say, well, no, that's not how trusts work, we're not going to be doing that, then it's irrelevant because... And then finishing 2166, Lord Tomlin uses the Culliver example of if no such principle existed, this is right at the bottom, I see no reason why a dairy society in Wiltshire should not, by means of the exercise of such a power as the one under consideration, find itself converted into a boot manufacturing society in Leicester, with an obligation on the members to contribute funds to the new enterprise. We say that's what they were doing is looking at the purpose of the rule and imposing inherent limitations on its scope. So any amendment that went outside the scope of the venture, which we would say is the substratum in that case, would be outside the scope of the amending power.
But suppose the power of amendment was exercisable with, you had to have unanimity of the members. Nonetheless, would you say nonetheless they can't all agree to convert themselves from a dairy into a boot manufacturer?
I would say yes, they can, and as can beneficiaries of a trust who are all sui juris under the rule in Saunders and Vautier. So if you've got everyone that's interested and has full capacity, they can all get together and say, do you know what, we don't want this trust anymore, let's have it all, let's have the cash.
Yes, but we're talking about an amendment rather than a...
Yeah. But if they can say, give us everything, they can do something smaller than that.
So just to bring this back to this case, and I hope I'm not going ahead of where you're going to get to, what is your precise submission as to what the purpose of this trust is?
The benefit of the Wang family.
And the Wang family, you mean the benefit of the family of YC Wang and YT Wang?
Yes.
So it is it set out at the bottom of the second, it is the second schedule. It's for the benefit of the children and remoter issue of YC Wang and the children and remoter issue of YT Wang.
So that's the trust, or those are the objects of the powers of disposition. The trusts in Schedule 3 identify the same people, children and issue of YC and YT Wang. That gives, we say, the trust its purpose, which is slightly wider than that, because we widen the purpose to being for the benefit of the Wang family.
Now, where do you get that from?
Well, because there's a power of addition to the objects of the power of distribution, the dispositive powers. The Clause 8 says you trustees can add to the class of beneficiaries.
Yes, I appreciate that. But where are you getting the rest of the Wang family?
So, for example,
within the purpose?
So, for example, one asks oneself the question, well, if the trustees come across in 50 years' time a young issue of YC and YT Wang who dies prematurely but is married and has 3 minor children, the children will be all right, but who marries and leaves a widow, would it have been within the contemplation of the settlers, objectively speaking, to include that widow in the class of beneficiaries with a capital B?
So the power to add is extremely limited on your view, because the purpose is, I mean, you've expressed it as the family of the Wang family. I think you have to be more precise than that. But nevertheless, only because the Wang family, we're talking about YC Wang and YT Wang.
Yes.
Someone's got to have a definition of what the Wang family is what I suppose I'm saying. But you're then saying, well, the only addition that can be made under Clause 8 is a somewhat remote possibility, which is the type of one you've just given.
Well, one doesn't know until the situation arises, but what the question that the trustee would face if and when a situation arose is to ask himself the question, would the addition of this person, is it within the purpose of the gift that was originally made? If it is, then I can add them. If it isn't, I can't.
But how do you bring the widow into the purpose? If you're looking to the third schedule as the purpose of the trust, how can you then use the powers in relation to the capital B beneficiaries to extend the family trust beyond those who are specified?
Lord, I would put the purpose of the GRT as being for the benefit of the Wang family, by which I mean the family of YC and YT Wang.
But where do you get that from? Well, where's the objective basis for that submission?
Because the beneficiaries and the objects of the powers of appointment are the children and issue of YC and YT Wang.
Yes, but how do you expand beyond that? Objectively?
Because simply because the Clause 8 power to add to that class envisages the prospect that it might be used to add to that class. So there must be somebody that can be added to the class, and to maintain the purpose of the original gift as being for the children and issue, one can well see that stepchildren might fall within that class, a widow might fall within that class.
And isn't that because you're benefiting the existing beneficiaries by, in a sense, enabling their moral obligation to provide for stepchildren or widows or so on, to be provided for directly out of the trust fund?
Well, Lord, I would say it's not limited to that. I can see that it might be said that is, but take a widow, for example,
yes,
with no children.
So a widow of an issue.
Of an issue.
Motor, yes, go on.
Then the beneficiary himself is, or herself is dead.
Yes.
Himself, sorry, it's a
yes.
widow. And then, but the trustees might well wish to add the widow so that she could live, and that wouldn't be benefiting the dead beneficiary.
Well, it might benefit the deceased siblings, who might feel or might be thought to feel an obligation to their sister-in-law.
Yes, I see that, my lord.
But I mean, but the question would come back in a sense to the intention of the set law, wouldn't it? That would it have been reasonably and objectively within the contemplation of the set law in providing for their issue that in appropriate circumstances a widow of an issue could be added? I don't know why my screen is right.
Yes, Lord, that's
yes.
it.
Right. Can I, before we lose Holland Garney, can I just ask you a question, Garnsey, sorry, a question about that? Isn't it really a case about the limits on the power of a majority to bind a minority? I mean, because in answer to my Lady Rose's question, you agreed, and it's clear from the judgments, that if the members of the society had unanimously agreed to the amendment, there could be no objection. It seems to me to be, at best, some sort of an analogy to the
yes.
present case. It's not It's not directly in point, is it?
What it shows is that the power of the majority to bind the minority is limited by reference to the purpose.
Well, that's right. And you say, well, there are quite a certain number of common law and equitable rules which restrict the power of a majority to bind a minority, which are quite independent of what is being discussed in this case. But that's why I say perhaps at best it's some sort of analogy with the present case.
Yes, I mean, we draw on it, my lord, simply for the principle, and we say it is a principle, that powers that are expressed in unlimited terms can be limited by reference to the purpose for which they were given in the first place.
The relevant power there is not the power of amendment, but the power of the majority to bind the minority. And the power of amendment did extend to any change, but what the restriction was on what the majority could bind the minority to.
Yes.
So
yes.
it's a rather special case in that way. Distinct from our case, really.
It's distinct from our case. I don't shrink from that.
Yes,
I do.
But I mean, the notion that fiduciary powers must be exercised for a proper purpose plainly exists independently of Hole and Garnsey. I mean, I suppose I'm saying you don't really need Hole and Garnsey, do you?
I mean, that's just another way of saying, well,
Yes.
this is all so obvious, we don't know why you're bleating on about it, really.
Anyway, my point was I think that, as I say, I think that the focus in Hole and Garnsey is on a somewhat different point than is the focus in this case.
Yes, the focus is.
If I could come back to the point I was raising with you, you're accepting that Clause 8 goes beyond the class of existing beneficiary, and the reason you say that the outer limits of that power are the benefit of the Wang family, and you're relying on it being essentially a family trust.
Yes.
And therefore, while you can add, you're saying that there are distinct limits, and a stepchild and a widow would be within the boundary by analogy with the people who were benefited, but something completely outside the family would not.
Yes, Lord.
Yes. But what are you relying on to make that submission in terms of the deed? Is it just the fact that the people specified in the second and third schedule are family members?
Yes. Children and issue stamps the trust with the family, its family nature.
Yeah, that's what I was wanting to get at, what you were saying.
Well, I thought right at the beginning you also mentioned the context of at the same time that this trust was created with a smaller amount of money, the Wang Family Trust was created with a much larger amount of money, and I think you were also relying a little bit on that context as to what this trust was all about.
Milady, yes. I mean, it's almost easier just to simply say, well, we can see very clearly what these powers were not intended to do, and they were not intended to be used, they were not conferred to be used to supplant the children and issue beneficiaries and objects of powers with Grandview as trustee of the WFT, because that trust was set up on exactly the same day, wasn't included as a beneficiary, and we say wasn't included as an object of the power. The trustees does not fall within the objects of the powers, something that I know that I said I'd come back to, and I'm awfully sorry to have not got to it yet.
Well, would that be an appropriate place to take the short adjournment?
Right.
Thank you very much.